Uh-oh, there's an escrow dispute on the horizon. So I'm gonna tell you a quick little story about something that's going on right now. My team also provides transaction coordinator services for some agents, and an agent that we do TC work for has a listing that is supposed to close in the next few days. Meanwhile, the buyer has now elected to cancel the contract. Well, here in Florida, and I'm going to speak to Florida, understand that your laws may vary depending on where you practice real estate at. But here in Florida, there's basically only a couple scenarios whereas a buyer can actually get out of the contract without risk of losing their earnest money. This particular scenario, none of those conditions apply. In my opinion, the buyer is at risk of losing their earnest money deposit should the seller make a claim for it. Now, also understand here in Florida, in order to cancel a contract, we have a form called a cancellation and release that both parties have to sign. And on that cancellation and release form, it gives instructions to the title company to whom the earnest money is to be returned to, be it the buyer, the seller, split up, whatever the case may be, whatever the parties agree to. So it requires both parties' signature. So in this particular scenario, because we're so close to closing, this agent's seller already moved, right? He already rented a new place for temporary housing, already paid movers, quite a bit of money laid out already, I believe to the tune of about $7,500. So needless to say, the sellers are not very happy. The sellers would like to not only make a claim for their earnest money, but they would like to be reimbursed for the money that they've had to shell out that they're going to have to absorb now. Well, chances are the buyers are not going to agree to that. Now, one thing that I always instruct agents that ask me about different scenarios, one of the first things out of my mouth is always, what does the contract say? Because most of your answers, most of the questions you have in all of your transactions, the answers can be found in your contract. In our contracts, there's no provisions for the seller to recover those additional funds. They can, however, make a claim for the earnest money, but if the buyer does not agree, then that leads us down the path of an escrow dispute. So we have a couple situations here. All right, so we have a deal that's falling apart. We have a listing that the agent wants to retain the listing, obviously, and have a chance at another transaction together. But what happens often is these sellers, they get very emotional, and understandably so, but they also get very emotional and they feel like it's the agent's fault that this did not happen. That the deal fell through because the agent didn't do something. So we want to try to be sensitive to that. We want to maintain that relationship and make sure we're on the agent's side. In this particular case, the seller is ready to hire an attorney, the whole 9 yards. So my recommendation is, first of all, never discourage your client from seeking legal counsel. You're not ever going to win that battle. Only bad things can happen from that. It can come back to bite you. Never, ever, ever discourage that. Obviously, sit them down and explain the situation, explain the remedies as you understand them based on your experience and based on what the contract says, but do not cross any lines to where you're giving legal advice. Just explain the contract, read it word for word so that they understand what the contract states. Now, in this particular scenario, the seller wants to get additional reimbursement. Well, by all means, you have every right to take your seller's request to the other agent to see if maybe the buyer would say, yes, you're right, I did you wrong, I will pay the money that you've laid out. In which case, we have a win-win. Now understand, again, there's no provisions in the contract for that to happen. So if the buyer tells you to kick rocks, well, you kick rocks, right? Because you have no recourse to that. So this is where your seller has to seek their legal counsel. And in my opinion, again, not giving any kind of legal advice, just my understanding of the contract, their claim would be limited to whatever money is held in escrow. So at the end of the day, that would probably be the outcome should they go down the path of suing the buyer for specific performance, because in this particular scenario, there's no way the buyer can actually close. Our takeaway here is, first and foremost, we do not discourage our client from seeking legal counsel. Secondly, we want to do everything in our power to maintain that relationship. So if your seller has that demand, no matter how reasonable you feel it might be, you want to take that to the other agent and at least present it. It's much like an offer. You have to present all offers, right? So you want to at least present it. You want your seller to feel like you're doing everything possible to help them out of this situation so that next week when this deal is totally blown up, they don't strip the listing from you. You want to make sure they understand that you are doing everything in your power for them. So anyway, hope you find this helpful. Keep swinging.